So our next speaker is Devin McGraw, and Devin is the director of the Health Privacy Project at the Center for Democracy and Technology. There's a pretty extensive biography on Devin in your program, but maybe just some highlights is that she was selected by Catherine Sebelius, Secretary of the U.S. Department of Health and Human Services, to serve on the Health Information Technology Policy Committee. And she also co-chaired the Confidentiality, Privacy, and Security Work Group and was a member of the Personalized Healthcare Work Group. So she's going to talk today. Her topic is Minimum Necessary and Data Identifiability, a Next Frontier for Privacy. So please welcome Devin. Thank you.
Thank you very much. This is actually a presentation that's in a bit of two parts, because you'll see the title on the slides doesn't actually match what's in your program. And part of that is because after I had a chance to talk to Brad about what he was presenting, I realized that it might actually make some sense for me to talk a bit about a paper that we wrote almost a year ago that is looking at sort of what we have in de-identification policy today under HIPAA, or anonymized data. And I know there's no such thing as anonymous data, but I use this term anonymized to mean, you know, the data is designed to not be identifiable to the recipient. But I've been trying to take some of the thinking that was in this initial paper one step forward, which is sort of part two of what I promise will be not a long presentation and won't have any math in it whatsoever. I count Brad for my math.
I'm hurt.
Sorry. Which is to say that if we still believe in the concept that data that is not as identifiable as fully identifiable data does provide some greater protections for confidentiality, then where are the windows of opportunity to exploit that in current legislation, and what is it that we ought to be looking at going forward? And that's still a topic, one that I haven't written on, two that I'd like to write on, and so this is just the beginning of that exploration, and I think it actually dovetails nicely with what Brad didn't get to, which is, okay, so here's the lay of the land, and what do we do about it? Based on the facts, which is important, because one thing I'll say at the outset is that as a policy advocate, I'm not an academic. I try to distill what I read from academics and try to think about what can be turned into good practical policy. I don't like to make that based on fear or hyperbole. I'd much rather do it based on facts where we can. So it doesn't always translate that well in a policy context. As we well know, fear and hyperbole speaks loudly, but it's ideally not going to show up in my work. So let's begin here. This is a little bit about the project. I'm going to fast forward about this again. We're a public interest organization. We have offices in Washington, D.C. It's our largest one of 20. And we got 2 people in San Francisco that we now can declare as an office. But we're pretty small, and we always have been. And our primary focus is looking at workable, practical privacy and security policy solutions as we're sort of entering into this new world. Which age of privacy? It's probably a mix of all of them, because we try to take sort of what's on the table and think about ways to morph it rather than, you know, is this the right regime to begin with? But at any rate, that's what we do. We have written in 3 places on this issue. The biggest one is the white paper, and there's the link. Then we do these shorter policy posts. And then to get an even shorter exposition of our position on this, there was an iHealthBeat Perspectives article. So how do we get into this space? Well, you know, there's a lot that's being said about de-identified data and this notion that, in fact, maybe there isn't such a thing as de-identified data anymore. That's the fear and hyperbole part, but that's not without some evidence, because clearly, as Brad's presentation showed, and as we've seen in some literature, we do need to be thinking about this because people have essentially cracked the code. We had a workshop, which I should have invited Brad to. I don't know why I didn't.
Because you had LaTanya.
We did have LaTanya. We also had Cynthia Dwork from Microsoft. Mark came as well. We had Maya was there. So lots of folks who are in the audience, and we just again wanted to tease out exactly what was going on in the space from a factual matter, and then think about what we might do going forward. We closed it to press and didn't record it so that folks could talk more freely. So my account of it is the only one that's available. If people think it's wrong, they can feel free to let me know. Brad has already talked about what we mean by de-identification. He put up basically the safe harbor standard, which is the one that's used most often because it's real easy for a healthcare institution just to strip out identifiers, and therefore then it is deemed to be de-identified and falls out of HIPAA protection altogether. There also is a statistical method, which requires that a qualified statistician, who there's no set of qualifications, no one becomes a qualified statistician, but a statistician must determine and then document that the risk is in fact very small, that the information that's in that data set could be re-identified by the anticipated recipient of the data. And you can't know going into this that in fact it's re-identifiable or all bets are off. So again, if it's de-identified, it's not protected. No constraints on use, no requirement to enter into a data use agreement and make certain commitments. Now, there are definitely institutions that say, well, that's the rule, but we're not comfortable with that, and they require data use agreements, and I say, bravo, for all sorts of reasons. We contrast that with the limited data set, which is actually quite similar, but does have two very important identifiers that are allowed to be in there, which are quite commonly used for research and public health purposes, if not healthcare operations. In this case, you actually need a data use agreement and a commitment not to re-identify. And as Brad noted, I mean, this is the first time I've seen that presentation. In some states, the distinction, at least between the safe harbor standard and the limited data set, may actually not be terribly significant. In other states, it in fact is. So why did we do all this? Well, again, we're sort of, we do look at the literature that raise questions about the de-identification standard. Most of what I've read, and I can't say that I've sort of exhaustively surveyed the field, but most of it is criticizing the safe harbor standard, which is to say that we have this static notion of de-identification that's based on this idea that if you remove certain identifiers from a data set, it is never or highly unlikely to be re-identified. I think what we know from Brad's presentation in the literature is that we're not living in that kind of a static environment. And then in fact, the risks that data will be re-identified has to do with who the recipient is, what data they could have access to re-identify, whether it's publicly accessible or through private databases that they have access to, and what's their motivation to re-identify. Do they really care about that, that it's me in that database, or do they care more about the data and that question that was raised about, well, who is really doing these attacks in ways that are malicious and are aimed at getting the identity. And I think we could speculate all day about who those might be, and I don't suggest that it's unreal, but it is a factor in thinking about these policies. We did say in our paper that we thought it was very important to preserve some option of de-identified data, because I think as Brad's presentation noted, very low risk of re-identification. But again, it is not, that is going to be dependent on the context of its use, and so it treats it again as the holy grail is not appropriate, but nevertheless there's still some value there. And we probably also still need to have some sort of safe harbor standard, because the statistical method, again, depending on the quality of the statistician doing the analysis, is still probably better, because you've got somebody sort of examining what the circumstances are around the data use and able to evaluate what are the genuine risks based on who's getting it. But again, not all of our healthcare institutions that have a need to use data or have a need to share data are going to be able to access and pay for that kind of expertise. So, so what does that mean? We've said a couple of things. I want to fast forward to our recommendations, which are sort of in two camps. One is to say, that we need to stop demonizing de-identified data. Not all of us are the we that have done this, but nevertheless, again, considering that there is, if you believe that in fact confidentiality is better protected the less identifiable data is, I believe that's true, but I invite you to push back during the discussion period. We need to actually be presenting more options for anonymization and strengthening them, and above all, making sure that there are penalties for re-identification, which is part of the big problem that we have with the de-identification standard. But it shouldn't be an either-or proposition. And in my view, we shouldn't treat data as all the same, because we're starting to poke holes in, again, this notion of the holy grail of de-identified data. You know, again, we have HIPAA permitting use of fully identifiable data where lesser identified data would suffice, and healthcare operations, in my view, is a big example. It's too big of a laundry list, in my view. People will argue with me about this, but nevertheless, a lot of it are sort of functions that ideally could be done with lesser identified data, but for which the two options that we have on the table, the limited data set and de-identified data, are pretty rigid and lack a lot of flexibility to be useful in the hosts of contexts where we'd ideally like to see less identifiable data used versus fully identifiable data. So here's the specifics here. We need to strengthen accountability across the board and treat de-identified data as though it still raises some risk and protect it according to the level of the risk that it raises. So one of the things that we suggested in the paper is let's do data use agreements even for de-identified data, because at a minimum, we've got an accountability mechanism for re-identification. It's not a perfect one because it depends on the data holder, the entity that shared the data, actually enforcing the contractual provisions. But nevertheless, it certainly would be better than what we have now. The most ideal, of course, would be to have some legislation in place that would hold you accountable for re-identification even if your contracting partner didn't. We need to expand the data anonymization options, again, beyond limited data set and de-identified data. They're very rigid. Again, statistical option, I think that's not what I'm talking about when I say they're rigid. It's the safe harbor with the, remove these 18 and the data is safe. Limited data set, remove these 16 and the data is safer than fully identifiable data and more useful for the purposes for which we want to encourage its use. But still, it's not flexible enough to account for the fact that when we have any particular need for data, how much data is going to need to be in that data set is on the purpose for which it's sought. We don't have any incentives to use lesser identifiable data. Now, one could argue, and this is what one of the things that I'm trying to explore, is whether the minimum necessary standard under HIPAA, whether that provides the justification for using lesser identifiable data than fully identifiable data for the range of purposes under HIPAA for which today you can use data without the need for patient consent, and there are absolutely no limits on the it can be fully identifiable PHI data. And that's something I'll talk about more in a second that I would like to explore. To the best of my knowledge, the Office of Civil Rights that enforces HIPAA has never thought about, first of all, they haven't given very much guidance on minimum necessary to begin with, but it hasn't really been conceptualized as degree of identifiability of the data. Instead, it's been, well, how much clinical data needs to be in what I'm sending to the payer or what I'm using for healthcare. It's never applied to treatment disclosures. And I'm not sure that it should, but you can push me back on that one too. Some other ideas that we had were designating de-identification centers of excellence. So this is somewhat like the model in Ontario, where they sort of had designated centers that do health research that have pretty rigorous standards that they have to uphold and that they're held accountable for. Where there's strong de-identification expertise, like at Vanderbilt. There could be a way for, maybe that's the safe harbor that you create in the law, that if you've run your data through one of these centers, then you're sort of deemed to be okay. But again, we want to make sure, even as I say that, it's not a static process. It's about considering where the data is going, what data they have access to, what's their likely motivation to re-identify. Education and training of staff that are de-identifying data. Perhaps this can be something also that the Centers for Excellence do. That safe harbor standard is so easy to use, and yet because of its ease of use, there's just sort of no questions asked about whether that's sufficient in the context that the de-identified data is being used. And then our last recommendation is really about increasing public transparency regarding uses of de-identified data. I think a lot of times the media reports conflate the data mining issue, and the assumption is that data mining is done, I mean, I think depending on the lens through which you look at it, you're either assuming that data mining is about de-identified data, oh, but I've heard that de-identified data can all be re-identified, so what's the difference? Versus they are mining your individually identifiable health information out of prescription drug databases, which as far as I could tell is not permissible under HIPAA already. But nevertheless, there's not been a good rigorous debate with the public even about how data use is occurring to de-identify data, and it's important. So even if we don't put a consent mechanism on this, which I would not do, but I suspect there are some people who would, because I don't think it's very privacy protective, we can talk about that too. It's still important for people to know how their healthcare institutions use data. I mean, that should just be part of the public dialogue, because sometimes it's not just about the privacy. I don't really like the fact that the data is being used for this purpose, and we ought not to have that happen. And that might get to the fourth age of privacy, where we're not going to let you do this with data. I don't care how identifiable it is. It's just wrong. So here's my opportunities to try to shape policy in a slightly different direction on this score, and for which I'm always seeking feedback. Some of it I don't listen to, but most of it from here I probably would. HHS is supposed to do a study on de-identification, which actually Brad is pulling together a session conference meeting that a bunch of us are going to next week. The department is also supposed to issue guidance on minimum necessary standard, and that provision is wrapped into what I label a preference for using the limited data set in order to meet the minimum necessary standard. Now, it's not a very strong preference. Essentially, you don't have to use limited data set if it won't work. But what I like about that positioning is it frames the conversation about this minimum necessary guidance in a way that I think allows me better able to argue that what we should explore in minimum necessary is data identifiability, as much as, you know, amount of clinical data that is needed for a given purpose. So really the part two piece about it is exploring this notion that, you know, given what we know about the likelihood that data can be re-identified from either a limited data set or de-identified data, but acknowledging, you know, is there still a distinction to be made that's meaningful in privacy and confidentiality discussions between fully identifiable data and data that does have identifiers stripped out of it? What is the best way to evaluate that and put a set of rules in place going forward so that we're not in the situation that we're in today, where we're sort of waiting for the next disaster to occur with respect to de-identified data and making data publicly available for what we think are good purposes, and then we turn around and find that we've given people greater tools to re-identify it somewhat inadvertently. How do we legislate the notion of what the data recipient's motivation might be? This question that was raised about, you know, who really does have malicious or inappropriate intent with respect to the data, and then thinking more about, you know, okay, if you're still with me and you think that there's still some more, that confidentiality is better preserved with less identifiable data, and we agree up front, I would hope, that we need stronger protections against re-identification at the first stage, and that we need security protections around this data as well. What are the ways that we can promote for the healthcare industry, which is largely what these rules are directed at, so they got to be useful and they got to be operational. What are ways that we can promote the use of less identifiable data in order to advance this forward? And so I'll stop so we have plenty of time for discussion, because there are clearly some really smart people in the room, and I could use the help. So.
Okay, so any questions first for Devin? We can have some afterwards for Brad also.
Well, I have two questions, and they actually go to both of your talks. And the first one goes to the conclusion that the re-identifiability risk is quite low unless you've got super sophisticated attacks. And I'm not sure I've ever seen data that would support that. So for example, when Brad, you or one of your colleagues does a study, you go through very carefully all of the 17 specific and one general rule about what you need to do to de-identify data. My guess is, and this is just a guess because I have never seen a study on this, that many covered entities are not nearly as careful in their de-identification process. And if we just sort of look to the level of compliance with HIPAA in general, we might draw the inference that at least some covered entities are somewhat sloppy in their de-identification. And if that's the case, then the likelihood of re-identification goes up and up and up. So if we, I think we make a mistake if we just use your theoretical low level of de-identifiability based on the assumption that we've got very careful conformance with all the HIPAA requirements. So that's the first comment and question. The second is more along the lines of Devin's talk, and that is how should we begin to think more specifically about what a HIPAA regime where, in addition to minimum necessary, we've incorporated the concept of least identifiable form means. I know at NCVHS we've been, well, now we in the past, they, I don't know, in the present, have, you know, tossed this idea around as a concept. And have you thought about sort of practically how that would work? Are we talking about encryption? Are we talking about partial de-identification? What uses? You mentioned some of the sort of uses that you might see that go to. So do you have any more specific guidance about where you see that concept playing out?
You can go first.
Okay.
You don't want to go first? No. Okay. Well, I've thought about it. I'm just beginning to think about it, and clearly if I'm going to write a paper about it, I got to do a lot more thinking about it. But taking treatment off the table, I know not everyone would take treatment off the table, but I would take treatment off the table, in part because I think we have a big enough problem with not enough data flow for treatment, and we don't want to make that worse by forcing providers to think about whether, the data that they're either trying to collect or that they're disclosing is the minimum necessary needed to treat the patient. I get that people would disagree, but in terms of payment is another one where it's a little bit of a tougher nut to crack, because while minimum necessary does apply to disclosures for payment purposes, the payers control the purse. And if they ask for the whole medical record, it's difficult, I think, for a provider to say, even if the law's on their side, to say, well, I don't think you should have it because I don't know why you need to know this in order to pay this particular claim. So I think more about healthcare operations, I think more about research. And so what I'm toying with is the technology pieces of this, so encryption, hashing, ways that you can in fact achieve statistical de-identification without going through the stripping of the particular data points, I think is definitely worth exploring, although that to me is more of you can achieve de-identification through those methodologies. So that's not exactly going in the direction that I was hoping to go, which is, can you actually create model data sets that and maybe it's a combination of technology and policy. Can you create model data sets that you can offer to, that are not static in time, that maybe they're time limited and need to be reassessed for their protective capacities given the ever increasing access to data from public databases? But are there models of data that can in fact be more protective that we ought to think about using? Now this knowledge flies in the face of what my premise, which is that in fact the data risk is not about the data itself, but about who's getting it and what's their likely ability to connect it to other data, re-identify, and then what's their motivation for identifying it. But I'm seeking a marriage that may not be possible between something that's simple and easy for providers to use, but that also takes us farther than where we are today, which I think is arguably untenable going forward. So it's not a terribly specific answer, but mostly I want to use these opportunities where I'm able to sort of talk about the work to generate some ideas. People can identify who's writing papers that I haven't seen. It's likely to be considerable because I'm reading all about meaningful use these days, and it has nothing to do with de-identified data. But maybe it's not a great answer. I don't have the specifics yet, and I wouldn't write until I did. So
let me just come back to your first question. This notion of do covered entities have due diligence with respect to their de-identification practices? I don't have enough evidence. I don't think anybody has enough evidence because nobody's ever really audited the entities with respect to what de-identified data they share. I can give anecdotal evidence of places that I've gone into to consult for, where they show me their de-identification model, and then I go, but that doesn't satisfy the third. For instance, I've seen places that think that they can disclose, I'm not telling where it is, but places that they think that they can disclose like month or the date at which something occurred, but they go, but I'm not telling you who this person was, and the data's been aggregated. It's like, it doesn't matter. That's not the standard. You can't give out these features. And so there's some confusion about how the standard should be applied in certain circumstances, because some people think that the standard only pertains to microdata, individual level records, and that when you start disclosing aggregate statistics, it doesn't apply to them, which isn't true. But these types of clarifications need to be made, and hopefully when the guidance report comes out for HHS, this will be more clear. It still doesn't mean that you have a compliance officer within the organization that knows how to, make people abide by it. But I don't know how you would go about doing that right now. But
Well,
maybe you have ideas.
Just a quick follow-up. I think it will be a great study for your next project, or maybe your 10th project, is to take a look at the 17 specific fields and say, okay, what happens if in de-identifying they screw up and don't take out number 5? What happens if they don't take out number 11? And I think just seeing that would, to me, very clearly illustrate the dimensions of the problem that we have as a practical matter, not as a theoretical matter.
It requires having a bit more of an understanding of the data sets that are out and be used for linkage purposes. And I'll tell you, so LaTanya is fantastic in this respect. So she's actually formed a company in which she's gone off and purchased a lot of the data sets that exist in the United States to try to determine if you're going to share a data set, then she's going to give you an idea of what's going to be the result in terms of linkage capability. That requires a lot of power, it requires a lot of money, because you've got to go off and say there's 1,500 data sets that exist out there. It's going to cost me several $1 million to purchase them all for me to give you an exact answer. But it can be done. Doesn't mean that it can't be. Maybe if you form a Center for Excellence, maybe we could actually do that. By we, I mean the de-identification community. I'll say one other thing, because I keep looking at Stefan and it keeps reminding me of it, which is that one thing that has not been done is assess the relationship between the HIPAA standard, the Safe Harbor standard, and unstructured data and natural language data. So some of the work that people have been doing is trying to figure out how to de-identify natural language data. And because most of the clinical notes are what researchers really want to work with. They don't want to work with standardized ICD-9 codes and CPT codes because it obscures what really happened to the patient. And so they say, well, give me the text. And you say, okay, well, I'm going to put it through this little scrubbing tool and it's going to spit something out to you. And then you go, there's a lot of really sensitive information in here that I could probably use to identify somebody. Like the example that I give of this to people is, and maybe it doesn't work so well here, but in the state of Tennessee, probably about 2 years ago, we had a case in which there was the famous quarterback of the Tennessee Titans football team who kind of had a psychological conniption and went AWOL and then was found at somebody's house with a gun in his car, right? And everybody goes in Tennessee goes, oh, it was Vince Young. I go, yeah, exactly. And there's nothing in HIPAA that would have prevented me from sharing that data because I didn't give you any explicit identifiers, any of them. And so you have to ask this question of what does it mean for the data to be re-identifiable in that context? And I don't think that we have any good methods for doing so at the present time.
Yeah, and part of the reason why the Centers for Excellence piece is in here, and every recommendation that's in that white paper needs, which is why I'm thinking part 2, where am I going with this? But was to think about sort of these folks that have this expertise, but I didn't even consider the cost question.
So Devin, I had a quick question that you hinted that with de-identified data sets, when there's some due diligence done, then the individuals aren't obviously identifiable, and there needs to be a join issue, presumably done by someone with malicious intent. You hinted that there perhaps that's the step that needs to be regulated, needs to be enforced more than the de-identification, because if de-identification happens too much, then the data becomes useless. Could you perhaps elaborate more on what possibly could be done to enforce the join, to say, well, we have the de-identified data sets, and in order to be useful for someone with malicious intent, they have to be joined. Can we enforce, can we regulate that join function as opposed to regulating the de-identification more and more?
Right. There are already examples of, regulating the joining function, and they're the ones that some of the ones that Professor Terry raised earlier, which is to say that there are absolutely things that cannot be done with data, even if it's so-called de-identified. So Gina was raised as an example. If we got non-discrimination in health insurance or employment on health conditions legislation, that would be another one. Stronger prohibitions against marketing. And some of the states in New England have been going in that direction, and they're absolutely directly regulating, data that's not patient identifiable, but in this case is prescriber identifiable. I've raised concerns with those statutes because, unfortunately, the definition of marketing is a slippery one, in that, one person's marketing is another person's legitimate patient education, and it sometimes depends on who's doing the communicating. Yeah, I think you can.
You might want to repeat his question.
Okay, sure. Okay, so, yeah, so the question is, can you regulate the re-identification and say that of de-identified data set? And I think you can, although it's a little tricky, in part because you have this HIPAA structure that's based on covered entities, right? So Congress would actually have to make a more broadly applicable data rule, like you've got the data and you can't re-identify it, and I don't care if you're, Mayo Clinic or you're Microsoft or you're some crazy individual. Yeah. So, and Congress has been real reluctant to go down that road. I mean, if you think about the privacy provisions in the stimulus legislation, it's the first time we've gotten privacy provisions out of Congress, because HIPAA is all in the rules. They punted, they couldn't do it. 3 years, they tried for 3 years, and all sorts of political problems ensued, and they couldn't agree on the details. Maybe they were trying to focus too much on the details, but nevertheless, it all went to a regulatory structure. We got privacy provisions in the stimulus legislation because they were part of a bigger bill where people had far bigger issues than arguing about whether, that sale of data provision was going to cause somebody some problem for their business model, which it will, but too bad.
So I have one potentially answerable question, one unanswerable question. The potentially answerable question is, you mentioned how, in a rapidly changing environment, that there has to be a certain degree, a certain amount of nimbleness to adapt to that, which seems counterintuitive when we talk about regulations, and in particular legislation. So I would like you to comment a bit more on that, about are there examples of nimble regulatory environments that could potentially be a model for this space? The unanswerable question is, are we really talking about a delimited time frame where the concept of privacy has any meaning? And what I mean by that is that there is so much information about all of us everywhere that in some sense, when do we cross the threshold that there is in fact, privacy is nothing but an illusion?
Oh, the privacy is dead argument comes up all the time. Right. I think if you ask people about, well, first of all, my job would go away, so I have to agree that there's some requirement for it to be there. There are enough people who still answer surveys at a pretty vigorous rate about their concerns about privacy, and most recent with respect to electronic health records. Some of the surveys cover de-identified data, and to varying degrees they're useful. But nevertheless, whether it's a perception problem or a reality problem from a policy perspective does not matter. People care about this. They care about what happens to their health information, and if they don't trust it in some way, shape, or form, it will impact their health care, because they won't go or they won't share what's really going on with them. And we know that still happens, even if they're under some illusion about how much privacy they really have. It is nevertheless an important value that is embedded in our Constitution in some way, shape, or form, and is part of, and in fact, it might even get more attention with this sort of increasing political movement to individual autonomy and take care of yourself. And I don't know, I sort of look at the teabagger movement as being a push back toward, principles of this stuff is mine, and I want sort of more ability to control where it goes, and whether that's money or information. I haven't really teased that out in degree of detail either. But in terms of models, Maya mouthed to me, IRBs, which I'm sure all of you really know what those are, but in essence, they're the mechanism, either IRBs or privacy boards, the mechanism by which research can go forward on data without consent of the patient. And so there's this process that's built in within institutions to weigh what the risks are, evaluate the purpose for which the data is sought. It's not a perfect solution, because I think anybody who's worked with IRBs, and particularly IRBs across institutions, that there are widely varying ways that the rules get interpreted and those decisions get made. Yes, now you only asked for an example.
Can I take your privacy as an illusion aspect? So I'll say two things. First of all, the type of data that we're talking about is not necessarily information that is normally disclosed in a public setting. So we're asking what happens when we actually lower the barrier of collection of information. And so that's just one thing I want to make clear. The second thing is that even when people do make that information available, they do so without understanding the consequences sometimes. And I'm going to invoke a friend of mine. So Alessandro Acquisti is an economist at Carnegie Mellon who's done some fantastic work on this that shows that people are willing to give up information for the smallest of services, despite the fact that they know that they may regret this in the future, because they go, I really want that candy bar right now. Yes, you can have my social number. Okay, there's a 95% chance that you're going to commit identity fraud against me in about 2 days, but it's only 95. It's not 100%, right? So, but people recognize that there's this notion of remorse and regret afterwards. And so at some point you have to come back and say, okay, so if this is information that was not in the public domain to begin with, and you're telling me right now that it's okay to go out there because, I'm recognizing that privacy isn't that important, I may feel that in about a week or a year from now. I'm really hoping that the system will go back to where it was. And so this is kind of the tension between the technology and the policy. Sometimes the technology gives you every wonderful capability in the world of being able to share information and use information, but the policy has to step in, or the regulation has to step in and says, whoa, whoa, whoa. That may seem like a good idea right now, but it's completely counterintuitive to the global good. And so that's my response.
One more, we're close to 5, so let's do that, and then put it back to Leslie and see if that's a wrap.
Yeah, it's been a very helpful conversation. Can you hear me?
Yep.
So two real quick questions. I'm interested in the research context, and the analysis has been in the context of HIPAA. And I think because of the data elements that are part of the identification standard. But under common rule, the standard is reasonably identifiable to the investigator. So are IRBs, hopelessly stuck with the subjective standard, or is there any way to bring some greater level of objective analysis, empirical analysis to what that concept means?
So if you put 6 different IRBs in a room and you show them the same data and you ask them if it's identifiable, you're going to get 6 different answers. 12. Depends on how many people are on the committee.
And
So-
put 6 HIPAA lawyers in there and you'll get 6 different interpretations of what HIPAA requires.
And so that's the problem right now, which is that there are no standards for what constitutes identifiable or even reasonably identifiable data. It depends on who you give it to, and the IRB really, I don't think that the IRBs are actually well versed of identifiability. You know, the IRB meeting was in Nashville this year, a couple months ago, and Dan Macy's presented this stuff to some of the chiefs of the IRBs, and it was people were surprised, extremely surprised by the fact that, okay, maybe you need to have a certain amount of malicious intent to commit the identification, but the fact that the data was exploitable to begin with was still surprising to them. And so I don't know if IRBs are the best place to adjudicate identifiability of data. That's one of my concerns.
Yeah, they are the final arbiter, but at least in the institutional
I know. I'm not saying that they're a bad thing. I just don't know if they have the right expertise.
Guidance to what that means would be helpful. So real quick, second question. I'm interested in cases, and I think those are always helpful. We're interested in biobanking, everybody is at this point, as they are at the individual. So are you aware of cases in which re-identification of tissue samples has led to any tangible harm from individuals by virtue of that re-identification, illicit re-identification practice?
Yes. So there was one with a paternity suit. There was one situation in which a kid actually went off and re-identified and was able to actually determine parental relationships that they did not want to have established. That was a problem. I don't have any good cases on a broader setting. You'd have to go ask Ellen Clayton, because she could probably, she knows more about the legal situation than I do.
But I also think that when you think about what the harm that is done, I think you need to broaden your lens a bit and consider what happens to the trust framework for people to know and be accepting of their data or their newborn's data being put in biobanks. There's a lot of newborn tissue sample discussions going on too. I know this is happening in Texas where they almost destroyed some. I mean, the fact is that people, even if there's no overt harm to an individual through a suit or discrimination, if people don't trust those frameworks where their data is being collected and shared, then they will revolt. And even if one individual doesn't suffer harm, that'll be the end of what could otherwise be a promising set of data for research purposes for years to come, and that would be truly unfortunate. So that is the bigger harm to me than, did anybody lose money? Did anybody get sued?
Just one small clarification. So this comes back to Nicholas's concept of the acceptable use with respect to information. So one of the things that we do at Vanderbilt, and I'm not going to hold us up on high and say that we do all the right things, but one of the things that we do with biobanks and with use of information locally is that we actually require people, the researchers who are going to use that data, they actually have to enter into data use agreements with the biobank to access that information. For every particular study that they're going to do, we actually have to issue a different level of IRB approval. Not level, but IRB approval for each study. So let's say I want to come and use that biobank for a study on diabetes. I have to get approval for that. If I'm going to do a study on, as I said before, long QT syndrome, you have to do an IRB approval for that. You also have to get approval through an operations oversight board. And that operations oversight board includes lawyers, ethicists, it includes scientists that are affiliated with the organization, as well as people from the community. So we don't do this without community input. And I'm not familiar with a lot of places that actually do it this way. LDS definitely does this, but there are not a lot of places in the country that have actually tried to reach back to the patients and say, is this something that we're supposed to be doing? Do you mind if we do this? And that's been, it's made it much easier for us to get allowances for doing research on what appears to be more risky data, because they feel involved. Whether or not the data is sufficiently de-identified is yet another question.
Okay, so let's go ahead and conclude that section and thank our speakers.